got to the age in my life where there are things I regret bitterly. One of them is I ever told anybody that somebody once said of my lectures that I didn't give lectures, I gave performances. I regret saying it, but anyway, I did say it. Right. First of all, I want to thank the students who nominated me. I'm extremely grateful to you. And I'd also like to thank all the students, well, everybody who's turned up today. You probably will work out very quickly that I supported Remain in the referendum, and also that I remain unreconciled to Brexit. So there was never any doubt that the topic of this lecture, would be Brexit related. But I decided that I wasn't going to talk about Brexit itself because the situation is so fluid. We simply don't know what's going to happen. We have no idea. But also because journalists and others have been writing about Brexit continuously. There have been 20 books published on Brexit in the last year, I think. So I didn't really think I had anything new to say on the subject. A long time ago, I went to a seminar. No, it wasn't a seminar. It was a conference in America at the time of the bicentenary of the American Revolution. And a very charismatic historian called Forrest MacDonald was present at the conference, and I spent 2 weeks talking to him and 2 weeks being inspired by the story he told about how the American Republic was founded. And so that was 1987. That was before I got to Bristol. And I've been reading about American history ever since. So this lecture is, well, it's a summary of the reading I've been doing on that subject for a long time. Now, the thing about, whenever I give the Best of Bristol lecture, I always write it. Do you know what you're doing? Right. Sorry. I thought you were going to be over there, but you're not. Right. It's fine. He knows what he's doing. So I always write it. There it is. I'm going to read this to you. I know you're not supposed to do it. It's very deeply uncool, but that's what I do whenever I do this lecture. And the slides will be operated by Yanis over there, right? So he is coordinating. Hopefully the whole thing is coordinated. But if it goes wrong, then the coordination breaks down, right? Okay, so I'll start. I was told to speak for 40 minutes. I reckon it'll take about 44 minutes, but we can time me. Right. This essay is inspired by a passage in the Federalist Papers written by Alexander Hamilton. I will read you the passage in a couple of minutes. The topic of the lecture is the debate surrounding the Commerce Clause and its relationship to sovereignty and states' rights that has been ongoing in America since the foundation of the Republic in 1787. When the 13 colonies won independence from Great Britain in 1783, they became more or less independent nation-states. In the 1780s, the possibility that the 13 colonies might come together to form a nation-state seemed remote. However, conflict between the states raised concerns that the experiment in republican government might end in failure. As George Washington put it, it's working, 13 sovereignties pulling against each other will soon ruin the whole. So what you can see there from my first quotation is a hostility to the notion of sovereignty from the founding fathers. George Washington had led the army. He had been the general in charge of the army during the War of Independence, and he was the first American president. It was concerns of this kind about sovereignty which led to the Constitutional Convention in 1787 and the writing of the United States Constitution. The clause of the Constitution which this lecture is concerned with is the Commerce Clause, and it reads as follows. Article 1, Section 8 grants Congress the power to regulate commerce with foreign nations and among the several states and with the Indian tribes. When I was preparing this lecture, I researched the economic literature on the Commerce Clause. There is very, very little that has been written by economists about the Commerce Clause. I found a 1911 article in the Encyclopedia Britannica on the Commerce Clause, written by an economist, Frank Fetter, but nothing else that I could find. To put that in contrast, the New Palgrave Dictionary, which is much more up-to-date encyclopedia, that has 2 entries on the European single market and no entry on the Commerce Clause. This does not imply that the Commerce Clause has been ignored by academics. On the contrary, the literature on the Commerce Clause is vast. It consists of numerous books and hundreds of academic papers. The literature is almost exclusively written by constitutional scholars and political scientists. In addition to this academic literature, justices of the Supreme Court, both in their judicial opinions and in their writing, have repeatedly made clear the centrality of the Commerce Clause to the Constitution. So I'll now read you 2 quotations. Harlan Fiske Stone was the US Supreme Court Justice. Let me just think about this. He was the Supreme Court Justice from 1941 to 1946. And he wrote this: "I believe it will be the judgment of history that the Commerce Clause, more than any other contributing element, has united to bind the several states into a nation." Then the second Supreme Court Justice I'm going to quote from is Robert Jackson. And this comes from a celebrated Supreme Court case, and what he said was, "Our system, fostered by the Commerce Clause, is that every farmer and every craftsman shall be encouraged to produce by the certainty that he will have free access to every market in the nation. Such was the wisdom of the founders." So the question is, why did the founders believe it was necessary to guarantee this right in the text of the Constitution? Alexander Hamilton, who was one of the most influential of the founding fathers, writing in Federalist number 11, set out the rationale as follows. The essay opens with the statement that a commercial justification for union between the states is one of those points about which there is least room to entertain a difference of opinion. Later in the essay, he writes a defense of free trade that could have been written by Adam Smith. So I'm going to read you now 3 passages by Alexander Hamilton from Federalist 11. It's very important that you distinguish between the 3 passages. The first passage says, "An unrestrained intercourse between the states themselves will advance the trade of each by an interchange of their respective productions." So that's just a classic defense of the advantages of the free trade that you could read in Adam Smith, in the opening chapters of The Wealth of Nations. Then he asks the second question. It may perhaps be replied that whether the states are united or disunited, there would still be an intimate intercourse between them which would answer the same ends. In other words, in this passage he's asking the question, do we need political union to promote free trade between the 13 colonies? Hamilton's answer to that question, this is passage number 3, says, "This intercourse would be fettered and interrupted and narrowed by a multiplicity of causes." Then the crucial sentence, "A unity of commercial as well as political interests can only result from a unity of government." That is the crucial passage in the Federalist Papers on which this entire essay is, if you like, constructed. And by the way, it's a very famous passage. That passage has been quoted by Supreme Court justices. It's in all the textbooks. Okay. Hamilton and most of the founding fathers believed that if the 13 colonies retained sovereignty with respect to commercial legislation, trade between the states would be fettered, interrupted, narrowed by a multiplicity of causes. These passages have been cited hundreds of times by constitutional scholars and referred to in the judgments of the Supreme Court. There are several points I want to make about Hamilton's argument for the Commerce Clause. First, Hamilton was not referring to tariffs or quotas imposed by the states on other states or on foreign nations. Article 1, Section 9 and 10 place restrictions on both the states and the federal government. So Article 1, Section 9 and 10 reads as follows: no tax or duty shall be laid on articles exported from any state. No preference shall be given to the ports of one state over those of another. Nor shall vessels bound to or from one state be obliged to enter, clear, or pay duties in another. So Article 1, Section 9 and 10 is dealing with a different problem from the problem addressed by the Commerce Clause. It's important to see these as two different problems which were separately addressed by separate articles in the Constitution. The problem about taxes and duties referred to in Article 1, Section 9 and 10, this problem arose because states with access to seaports exploited neighbouring states that lacked seaports suitable for foreign commerce. James Madison explained the rationale for this clause as follows: when the federal constitution came to be formulated, quaint comments were heard in the Constitutional Convention. North Carolina, lying between Virginia and South Carolina, was likened to a patient bleeding at both arms. And New Jersey, between Philadelphia and New York, to a cask tipped at both ends. What Article 1, Section 9 and 10 ensures is that the American Constitution created what we would call a customs union. So Article 9 and 10 relates to the customs union. To sum up the argument thus far, the clauses relating to trade in the Constitution result in the creation of what in the Brexit debate are referred to as a customs union and a single market. So there's a clause of the Constitution which creates what is in effect a single market. There's a clause in the Constitution which creates what is in effect a customs union. It is crucial to understand that Hamilton's view that intercourse between the states would be fettered, interrupted, and narrowed by a multiplicity of causes refers to what we now call non-tariff barriers. So Hamilton was thinking in terms of the distinction between non-tariff barriers and quotas and tariffs. The Commerce Clause has nothing to do with barriers to trade created by the Commerce Clause has nothing to do with barriers to trade created by tariffs or quotas. The creation of a customs union has been relatively uncontroversial, whereas controversy over the Commerce Clause has never ceased. It's been going on for 200 years. To understand the controversy, we need to think about the meaning of the phrase non-tariff barriers. Most of the remainder of this lecture is about the nature of non-tariff barriers. What does it mean to create a non-tariff barrier? What does it mean in political and social terms to remove non-tariff barriers? Before I turn to that question, I want to recall that the purpose of the Commerce Clause was about ensuring free trade between the newly independent colonies. The opening paragraph of a 1999 paper by Paul Krugman about trade agreement reads as follows: if economists ruled the world, there would be no need for a World Trade Organization. The economist's case for free trade is essentially a unilateral case. A country serves its own interests by pursuing free trade regardless of what other countries do. Terribly important to get that into your heads. The importance of this argument cannot be overstated. The classic case for free trade made by David Ricardo in 1817 is based on the theory of comparative advantage. According to this theory, countries need no inducement to adopt a policy of free trade. Once they have read and understood Ricardo, countries will unilaterally choose to dismantle any and all barriers to trade because it is in their interest to do so. So you don't need to put it in the Constitution. You don't need to guarantee it, either in Article 9 or 10. It just doesn't have to be there anywhere in the Constitution. Krugman quotes the French 19th century economist Bastiat, who said as follows: "It makes no more sense to be protectionist because other countries have tariffs than it would to block up our harbours because other countries have rocky coasts." Krugman's paper is about the role of the World Trade Organization, but the argument applies to the need for the Commerce Clause as well. If the 18th century founding fathers had been influenced by the 19th century classical economists, David Ricardo and his followers, the Constitution might never have been written, at least not in the form it took. The contrast between the intellectual climate inhabited by the 18th century American founding fathers and the 19th century liberal free traders is telling. To a 19th century liberal free trade prime minister, such as William Gladstone, the rationale of the Commerce Clause would have been a mystery. Gladstone's biographer, Colin Matthew, describes an article written by Gladstone in 1890, this is towards the end of his life, and he describes the article as perhaps the most deductivist account of the case for free trade that has ever been made. Gladstone was astounded when in 1871 some of the colonies began to impose tariffs. By 1871, Britain had unilaterally reduced all its tariffs to zero. In other words, the Ricardo journey to free trade had been taken by Britain. Gladstone believed that all other countries in the world were going to go down the same route. He believed that enlightenment would eventually lead to world free trade based on unilateral decisions by individual countries. This is what Gladstone says: "Do I understand that New Zealand may admit free shoes made in Sydney and tax at any rate she pleases shoes made in Northumberland?" The contrast I have just made between the American 18th century founding fathers and the position of the mostly English and Scottish classical economists is fundamental to the story told in this lecture. I will refer to the 18th century view as Hamiltonian, and I will refer to the 19th century free traders by the phrase Ricardo Gladstone. So if I talk about Ricardo Gladstone, I mean the 19th century liberal free traders. If I talk about Hamiltonian, I'm talking about the 18th century case for free trade. Alexander Hamilton and most of the other founding fathers would have been astounded by what they would have regarded as the naivety of 19th century Ricardo Gladstone free trade liberals. The international order that was built up after the Second World War represented a return to the 18th century view that free trade requires international cooperation and the pooling of sovereignty. The post-war international order includes both the General Agreement on Tariffs and Trade, the GATT as it became known, and the European Community. The pooling of sovereignty required by the GATT and the European Economic Community are different in degree, but it is a difference in degree, not kind. The fundamental principles upon which these institutions have been built are the same. The architects of both the GATT and the European Economic Community took it for granted that to realize the benefits of free trade, tariff reduction must be the result of multilateral agreements rather than unilateral action by individual governments. Moreover, these collective agreements could only be maintained if they were supported by an enforcement mechanism. The architects of both institutions took it for granted that some of the time countries would fail to comply with their obligations and that sanctions would be required to ensure compliance. The architects of these post-war agreements took it for granted that the 18th century approach, rather than the American 18th century approach, rather than the British 19th century approach, was required. I'm now going to return back to the Commerce Clause itself, and I'm going to work my way through 5 questions about the Commerce Clause. These 5 questions about the Commerce Clause are intended to help you understand how fundamental it's been in the American political system, despite the fact that on the face of it, it's about creating free trade. So first of all, my first question is this: why have so many constitutional scholars viewed the Commerce Clause as the single most important grant of power to the federal government in the Constitution? Well, in one sense, the answer to that question is the rest of this lecture, but I'm just going to give you a few brief quotations to give you an idea. Writing in 1898, Parmelli and Egan stated that the Commerce Clause of the Federal Constitution is now, in its nationalizing tendency, perhaps the most important and conspicuous power possessed by the federal government. Writing in 1937, Felix Frankfurter states that the Commerce Clause, by its own force and without national legislation, puts into the power of the court to place limits on state authority. The result is that though we are a federation of states, we are also a nation. The most recent comprehensive history of the Commerce Clause was published in 2004 by Boris Bitka. In the first chapter of that book, he states without qualification, as just taking it for granted, that the Commerce Clause is the king of the constitutional castle. In 1932, Bernard Gavitt published a study that lists every single case considered by the Supreme Court and decided under the Commerce Clause between 1824 and 1932. He came up with a total of 839 cases. What he then does is he splits these cases up into cases where the congressional regulation was upheld, cases where congressional regulation was not upheld, state regulation upheld, state regulation not upheld. Now the detail of that is not important. What you can see from this list is that both state and federal legislation has been both upheld and struck down. This is precisely what you should expect in a federal system, where the role of the court is to adjudicate in conflicts between the federal government and the states. That judicial role in a federal system, you can't have a viable, workable federal system without a court reaching these decisions. By the way, if that list was brought up to date, if we went from 1932 up to the present day, the number of cases would much more than double, because the number of Commerce Clause cases has been steadily increasing. Question 2. Well, 5 questions. We're on the second question. What is the dormant Commerce Clause and why is it so important? The dormant Commerce Clause has 2 parts. It's a positive grant of power to Congress, and it's a negative limit on state legislation. The positive grant of power gives the federal government the right to pass legislation regulating commerce, as you would expect. The negative grant of power prohibits the states passing legislation that burden or discriminate against interstate commerce. Now, when the Constitution was first written, it was believed that the task of enforcing this negative component of the Commerce Clause would fall to the federal government. So it was believed that the federal government would every now and again step in and, if you like, veto legislation passed by the states. In practice, that's not happened. Why not? Because legislative chambers take time to deliberate. No democratically elected chamber will have the ability to keep track of the vast range of means by which subnational states can place burdensome restrictions on interstate trade. This has meant that in practice, enforcing the Commerce Clause has fallen to the Supreme Court. This might remind you of the role played by the European Court of Justice. Eurosceptics who complain that the ECJ places limits on the sovereignty of British governments are correct. It does. The fact that we are subject to decisions of the ECJ does indeed restrict our sovereignty. referring to the primacy of EU law, the British judge Lord Denning said, "The treaty is like an incoming tide. It flows into the estuaries and up the rivers. It cannot be held back." Lord Denning wrote that in 1974. No, yes, 4. That was a couple of years after we joined the European community. Just how old were you in 1974? Minus 20, thank you. Minus 20. Right. That's a good answer. Okay. This leads to the question, I think, the fundamental question is, are these limits on sovereignty justified? Do we need them? Now, I'm not going to go into a discussion about the fundamental political meaning of sovereignty or why we might like it. What I'm going to do is, the starting observation for which the rest of the lecture follows is this. All sides in this debate agree that trade is desirable. That is true on both sides of the Atlantic. In the USA, controversy has never centered on the desirability of trade between the states. In this country, at least in the Conservative Party, all the leading supporters of Brexit insist that they support the maximum amount of trade possible. I don't think there's any exception to that rule. So if this premise is accepted, that trade is desirable, the question becomes, must we restrict sovereignty to promote free trade? And the answer is, it depends on whether or not you think the American founding fathers' view of the 18th century or the 19th century Gladstone-Ricardo view is correct. According to the 19th century Ricardo-Gladstone view, there is no need to trade off sovereignty and free trade. We can have as much sovereignty and as much trade as our hearts desire. According to the 18th century view, there is no escape from the trade-off. Economic integration can only be achieved if we are willing to sacrifice some sovereignty. Question 3. What precisely is a non-tariff barrier? When I read students' essays about the single market, I always find that the subject that results in most confusion is the section of the essay where they try to explain what is meant by a non-tariff barrier. And the difficulty arises because there is no simple definition that is not hopelessly vague. Non-tariff barriers come in an infinite variety of shapes and sizes. This lecture is primarily about the regulation of interstate trade between the American states. If you are persuaded by the argument, you will believe there are lessons to be drawn for those of us on this side of the pond. However, at this point, what I'm going to do is I'm going to move in the opposite direction. To explain non-tariff barriers arising from state action in the USA, I will begin with a non-tariff barrier that has been discussed in the context of the European single market. And that's lawnmowers. Lawnmowers have become, if you're an aficionado of the single market, you know about the lawnmower regulation. Professor Catherine Barnard holds the Jean Monnet Chair of European Law at the University of Cambridge. Professor Barnard is to EU law what the US legal scholars I have been quoting are to American constitutional law. In 2013, Professor Barnard was commissioned by the Department for Business, Innovation and Skills to complete a review of the internal market. The example chosen by Professor Barnard in her 2013 review to illustrate a non-tariff barrier was lawnmower noise regulation. Commenting on the lawnmower regulation, Professor Barnard has this to say. At first sight, a directive regulating the amount of noise lawnmowers make is a prime example of the sort of rule that the EU should not be adopting. A quick reading of the subsidiarity principle would suggest that this is the very sort of measure which should be left to the member states to legislate on. The suggestion that this regulation might be unnecessary did not, in fact, come from the Jean Monnet Professor of European Law. It came, as you might expect, from British Eurosceptic MPs complaining about unnecessary legislation from Brussels. They were kicking up a huge stink about the lawnmower regulation. Now, Philip Stevens takes up the story. He's written a couple of articles in the FT on this, and I'm borrowing from him. Douglas Hurd, the Conservative Party Foreign Secretary, ordered an investigation into the origins of the Lawnmower Directive. What that investigation discovered is that the UK government had not only supported the European Community's directive, it was the UK government that had proposed it. At this point in the story, Philip Stevens reminds us that the government in question is the Thatcher government. Why had the UK government proposed the directive? And the answer is that Germany is a very lucrative market for lawnmowers. But the Bonn government had set a national noise restriction to lock out competition from the UK. So it required an EU directive to give British companies a foothold in the German market. Get it? I need some nods, just say yes, right? Okay, the second example, we're now crossing the Atlantic, we're going to America, and this example is mudguards. Remember, what we're trying to do, we're trying to get our head around the nature of non-tariff barriers. Now, my mudguard example I first came across the mudguard regulation in a collection of papers published by the Liberty Fund. Now, it's not a coincidence that it's the Liberty Fund doing the publishing. They're a right-wing, free market think tank. One of the authors of the paper commented, "We have a time-pressed court that really should be doing more important things than worrying about mudguards on trucks in Illinois." I didn't know what that was referring to, so I Googled Commerce Clause mudguards. What you will discover, if you Google that, is that there is a 1959 Bibb versus Navajo Freight Lines Commerce Clause case. This Commerce Clause case has its own Wikipedia page. All the leading US Commerce Clause cases have their own Wikipedia page. So if you're interested in this, it's very easy to research these Commerce Clause cases. The state of Illinois, this is what happened. The state of Illinois had enacted a statute requiring curved mudguards rather than straight mudguards, which were required by most states. The Illinois legislature claimed that the curved mudguards were preventing accidents better than straight mudguards, although they were unable to produce any evidence to support this claim. The plaintiffs were a trucking company, and they complained that they had to use one form of mudguard in Illinois and a different design in other states. By now you should be starting to work out what happened. The US Supreme Court struck down Illinois' mudguard regulation because it was considered to be in violation of the Commerce Clause. Now, if you look at the history of the Commerce Clause cases in America, there are hundreds of these cases, and I mean hundreds of them. And it's not just the ones that reach the Supreme Court. There are also lower court cases. There are enormous numbers that never get to the Supreme Court because they just get struck down before that. So what you need to be beginning to get into your head is that the task of striking down legislation constructed by states that creates barriers to trade is kind of never ending. It's like painting the Forth Road Bridge. When you've finished painting it, you go back to the beginning and you start again. It never ends. On both sides of the Atlantic, conservative supporters of states' rights express outrage against regulations that might superficially appear to be unnecessary. But when you look under the bonnet, you realize that the regulation is not just reasonable, but actually essential if we are to create a single market. In the USA, these complaints go far beyond obscure mudguard regulations. The policy proposals set out in the 1981 Liberty Fund publication, from which I have just read you an extract, would dismantle 200 years of Supreme Court Commerce Clause decisions. That publication is not an isolated example. Free market think tanks like the Heritage Foundation, the American Enterprise Institute have been criticizing Commerce Clause jurisdiction for decades. Nor is that all. Recent appointments to the Supreme Court have tilted the balance of the court in a much more conservative direction. And that is resulting in a much less expansive definition of the Commerce Clause. Thus far, the relevant decisions which are sort of limiting and restricting the Commerce Clause, they are significant, but they haven't transformed American law. But they may do. It is not inconceivable that they will. If you read, for example, conservative court Supreme Justices are playing a long game. One of the Reagan-appointed Supreme Court justices recently referred to the dormant Commerce Clause as a fraud. To a European audience, it is hard to explain how radical that is. But it's not an exaggeration to say that if the currently fashionable conservative view of the dormant Commerce Clause ever came to be accepted, the United States of America will cease to have a single market. And I'm not the only person who thinks that. There are constitutional scholars who are becoming increasingly concerned about the direction these conservative appointed Supreme Court justices are taking the court. Okay, before I proceed, I want to reread two of the passages I read at the start of the lecture. I'll read them quickly. First of all, there is the Harlan Fiske Stone passage. I believe it will be the judgment of history that the Commerce Clause and the wise interpretation of it have united to bind the several states into a nation. That was the first passage I read you at the beginning of the lecture. Then I read you a passage by Robert Jackson, another member of the Supreme Court. Our system, fostered by the Commerce Clause, is that every farmer and every craftsman shall be encouraged to produce by the certainty that he will have free access to every market in the nation. Such was the wisdom of the founders. So the question that I think should be, well, I'm kind of hoping that many of you are asking this question, is the following. Why have supporters of the free market rejected an interpretation of the Constitution that seems designed to promote the free market? It's very, very paradoxical. And that's a question about American constitutional jurisprudence coming from a conservative direction. But the same question arises in the context of the UK. The single market programme is probably the most powerful market-promoting measure introduced by the Thatcher government. I have a vivid memory of sitting in 10 Downing Street, in the policy unit in 10 Downing Street, and I was told by a member of Mrs. Thatcher's policy unit that the single market programme was Thatcherism on steroids. I remember that was the quotation. The single market programme is Thatcherism on steroids. So the question is, why have free marketeers abandoned their support for something which seems to promote the market on both sides of the Atlantic? One answer is that both American conservatives and British conservatives have shifted. They've changed their view. They no longer support the 18th century view of how to promote trade. They've shifted and they now support the 19th century view of how to promote free trade. That is, of course, if you read what they write, that's what they say, right? It's quite clear that all the strongest Brexiteers are fundamentally supporting what I've called a Gladstone-Ricardo view of free trade. And if you read accounts which are critical of government regulation, federal government regulation governing commerce in America, the same picture emerges. It's very clear. However, I don't really believe, despite the rhetoric, despite the language, despite the arguments, I don't really accept that that's what's going on. I think there's something else going on. So that leads to question 4. It's question 4 and question 5, which, by the way, answer the questions I'm posing. So, why did the Commerce Clause become embroiled in the controversy over Roosevelt's New Deal in the 1930s? If you Google the 2 Supreme Court justices I have now quoted twice in this lecture, you will discover that Harlan Stone was Roosevelt's choice of Supreme Court justice in 1941, and Robert Jackson was nominated to the Supreme Court by Roosevelt at the same time. If you read a bit more, you will discover that amongst conservatives, these Supreme Court justices are intensely disliked. Harlan Stone, Jackson, they are hated by conservatives. Finally, you will discover that these judges upheld the constitutionality of Roosevelt's New Deal legislation. Moreover, almost all the important New Deal almost all the important New Deal decisions were decided under the Commerce Clause. In the 1930s and 1940s, Americans discovered that a truly national economy must be regulated by national legislation. Only the federal government could deal with the devastation wrought by the Great Depression. Only the federal government could guarantee the defense of workers' rights. The states couldn't do it any longer. If the Roosevelt New Deal legislation was to be upheld, rather than struck down as desired by conservatives, the Commerce Clause was the only constitutional mechanism for achieving this objective. Question 5, my last question. What does the Commerce Clause have to do with the passage of the civil rights legislation in the 1960s? By now I'm guessing, hoping, that you can kind of see where this is going. The constitutionality of the civil rights legislation was challenged by those who wished to defend segregation. If you are curious, the most important case is Heart of Atlanta Motel, Inc. versus the United States, 1974. The Heart of Atlanta Hotel was owned by a segregationist. He didn't want to admit African Americans into his motel. He wanted to continue with segregation. The public accommodations provisions of the 1964 Civil Rights Act made it illegal for him to prevent African Americans from coming into his motel. And he challenged the constitutionality of the 1964 Civil Rights Act. So the question is, was that Civil Rights Act consistent with the Constitution? That was the question the Supreme Court had to decide, and they decided it under the Commerce Clause. In other words, they decided that the federal government was entitled to regulate in this area because the Heart of Atlanta Motel was engaged in interstate trade. In the second half of the 20th century, American supporters of the free market have turned against the Commerce Clause because they have discovered that a national economy and national regulation go hand in hand. In this country, British conservatives abandoned support for the single market program when they came to understand the full implications of what was proposed. The social chapter and all the rights which liberals who value our membership of the European community, they are all packed up together with the single market program. I will finish this lecture with one more quotation from one more United States Supreme Court justice. The passage comes in 3 parts. It was written by Warren E. Burger, Chief Justice, U.S. Supreme Court, between 1969 and 1986. And he wrote this passage after he'd retired. I think it's in this century. I think he might have written in 2011, but I'm not sure. There are 3 sections to the passage. It is difficult to find words more significant than the 11 key words of the Commerce Clause. The freedoms created by our Constitution unleash the energies of a whole people in a way that never has been witnessed in all history. Then the second passage. One need only speculate on how a common market in 1789 might have affected the subsequent history of Europe. Without those 11 key words, we might have experienced the discord the European community has struggled to overcome in more than 30 years since the framework of its common market was established. Thank you.
We've now got time for questions. Anyone wants to put their hand up and kick us off?
Thank you for your talk, Gervas. Cheers. Is it the case that what the founding fathers of the American nation state set out to do was to just facilitate that, to essentially make the government's role as a facilitator for a single market, and that was what eventually led to the creation of the American nation? And could you also just briefly go over again what you meant by the Ricardo Gladstone school of thought? Thank you.
Okay. Okay, I'll take your first question first. No, you can't say that it was only. First of all, as you might imagine, there's a big literature on this, and you also might imagine different people give different answers, right? But everybody agrees, I don't think there's any disagreement on this, that one of the major factors that led to the calling of the Constitutional Convention in 1787 was trade disputes that were taking place between the 13 colonies. I read you that passage where, you know, I'm not going to read it again. Okay, so my answer is it was one of the main motivations behind writing the Constitution and ratifying the Constitution. That's my answer, right? What was your second question?
Could you explain again the Gladstone?
What subject are you studying at university?
Economics and politics.
Okay. In that case, I'm actually incredibly. You ought to. Sorry, I shouldn't. Sorry, I didn't mean it. I didn't mean it. Apologies. Well, you've studied. I mean, you know the theory of comparative advantage, and you know that what Krugman was saying in the passage I read you is that if you take the simple case for free trade, countries should pursue free trade unilaterally. They shouldn't require encouragement to do so. That was what Krugman was saying. Okay? And if you look at the 19th century literature, you will discover that that was actually believed. British policy for the best part of a century was genuinely based on the premise that Krugman in his article set out. Right? So, does that answer your question?
But how does that compare to the 18th century?
Well, the point is, in one case, free trade will emerge spontaneously. It's just like an invisible hand, isn't it? It's an invisible hand argument. Countries will adopt free trade because it's in their interest to adopt free trade. They will choose to adopt free trade, and they won't erect barriers once they understand and have read Ricardo. And that's what 19th century economists and politicians, they genuinely believed that. That's why Gladstone was shocked at the end of his life, because by 1890 he thought the message had got home. In fact, free trade, the 19th century free trade was beginning to crumble by the end of Gladstone's life. Is that okay? Jake.
You give a strong argument for the precedent of a federal European Union, but I wondered what your thought was on the precedent of the political implementation of it, because the 30 years of discord, say, of the United States were arguably during the Civil War, and in absence of the need for a civil war to consolidate a federal system, do you see an existing or potential political solution to a federal European Union?
I'm not a prophet. I don't have a crystal ball. I can't see into the future. I don't know, right? So, what I do know is that Eurosceptics have been predicting the breakup of the European Union since, what was it, minus 20? Right? And, you know, so far they're wrong. And, you know, if one of the things that Eurosceptics were very confident of before the referendum was that if we voted for Brexit, we would be the first of many. Right? They were also confident that the negotiating position of the European Union would not be unanimous. In other words, they didn't believe that the solidarity of the EU would hold together. Right? So they were, if you like, optimistic about the collapse of the European project. And actually what's happened is that Brexit seems to have strengthened support for the European Union. In opinion polls across Europe, the EU institutions have more support today than at any time about the last 15 years. So, you know, I mean, Jake, I don't have an answer. You know, let me repeat, I'm not a prophet, right? I don't know what the future holds. I don't even know whether we will be in the European Economic Community on the I don't know what's going to happen. I mean, think about the level of uncertainty that we face in this country at the moment. Staggering levels of uncertainty. And you're asking me, I'm sorry, Jake, I don't know. What I do know is what I believe in. What I do know is what I support. I know what my values are. I know what the policies are which I believe will work. That's okay. Back.
Sorry.
Hello. Would you argue that the arguments of the 18th, 17th and 18th century American economists would support the creation of, or for example, the UK joining the Euro, or the creation of complete free movement of people?
Well, okay. I mean, first of all, I think you've got to if you read something like Alexander Hamilton, if you read the Federalist Papers, you will find powerful general arguments in favor of a federal political system. And those general arguments are as relevant today as they were 200 years ago, I think. But so far as the detail is concerned, well, obviously not. I mean, you know, Alexander Hamilton was an 18th century American, right? Alexander Hamilton didn't anticipate the world that we live in today. So you can't say what his approach would have been to the welfare state or Social Security or Obamacare. We don't know, right? With respect to free movement, yeah, absolutely. Free movement is something that was challenged. So there are free movement cases in the Supreme Court, right? There's a paper, a very nice paper. It's called "Ain't Got No Do Re Mi," and that paper quotes the title comes from a Woody Guthrie song. And the Woody Guthrie song describes how, during the 1930s, poverty-stricken Americans had difficulty moving around the United States, because if they left their home state, their ability to access welfare fell. Right? So those limitations on free movement were challenged, and the Supreme Court ruled this discrimination, discrimination against out-of-state workers, unconstitutional. But that's not the only case. There are quite a few free movement cases in the history of the Commerce Clause. So I think my answer is yes, free movement has been seen as fundamental to I think my answer to you, I think the answer is to your the answer to your question is yes. Free movement you can interpret the debate about free movement in America. There are some very direct parallels with the debate about free movement in Europe. Yeah.
So there's something I've read about quite a few times, kind of lightly, in America, and it's the issue of Tesla electric cars, and basically.
I know nothing about Tesla electric cars.
Okay, it's not it doesn't really matter that they're Teslas. It's the method in which they're sold, that they're only sold online, and some states like Texas only allow cars to be sold through dealerships. Basically, this has been a problem for 10 years now, probably. Surely this should be something the Commerce Clause would have kind of sorted out by now. Do you think this is like foreshadowing the end of the Commerce Clause?
No, no. So I really like your question. Okay, so what has happened? I mean, the first thing. Let me just I'll try and give you some broad general answers. Eurosceptics complain that the single market program has never been completed. So they will tell you that the single market program is pointless because it hasn't been finished. Right? The single market program was supposed to be finished in 1992. But actually it wasn't finished in 1992. And the Eurosceptics who say the single market program isn't complete, they're absolutely right, it isn't complete. Right? And the reason why it isn't complete is because in a truly federal system, where the sub-national levels of government have real legislative power, it's very, very hard to create a truly single market. Okay, hang on. Now, in the context of America, what that means is that application of the Commerce Clause has in fact been uneven. We would imagine that when we think about America, we think, well, it's just a nation. We think it's a nation like Britain. So we would imagine that trade between American states would be as unproblematic as trade between Wales and England. Right? That's not true. Okay? And the answer has to do with the point I made a second ago about the incomplete application of Commerce Clause to commerce. So I'm going to give you two examples, and then I'll deal with your example at the end. The first example, and then you can Google both of these examples, incidentally. The first one is interstate wine shipments. Right? Prohibition was introduced after the First World War. When prohibition didn't work, when prohibition failed, it was realized they had to repeal the prohibition change to the Constitution. So there were the 27th and the 28th modification of the Constitution are about prohibition. One of them introduces it, the other one eliminates it. When prohibition was abolished, the only way they could abolish prohibition was agreeing to exempt alcohol from the Commerce Clause. Right? Because the dry states, the states that still supported prohibition, weren't willing to support this amendment to the Constitution. Right? So the compromise required exempting alcohol trade from the Commerce Clause. Now that has that then leads to these. I mean, one of the things I'm trying to explain to you is the incredible complexity of non-tariff barrier laws and legislations. It's just staggeringly complicated, and the people who understand it are lawyers. They are the people who know what's going on. Economists haven't got a clue, as far as I can make out. Now, what that means what the effect of this on the American alcohol market has been mostly to do with these interstate shipments of wine. So if you are a wine grower, if you've got an orchard, no, what are they? They're not called orchards. What are they called? A vineyard. You've got a vineyard in California. You want to sell your wine by mail order across America. You can't. Right? You can sell your wine to residents of California, but whether you can sell it to residents of other states depends on their local legislation. Right? So there is a campaign in America called Free the Grape. You can Google this, right? And Free the Grape has been attempting to apply the Commerce Clause to interstate wine shipments. And there is one of the recent, this is not minus 20. This case I'm about to discuss is within your lifetime, right? 2010 or something. And one of the comments in this 2010 Supreme Court case describes the situation between the states, and this is the quotation, a low-level trade war. That's America. That's the American states. A low-level trade war between the states over these wine shipments. Why? Because the Commerce Clause had been, because in order to repeal prohibition, they had to exempt this kind of trade from the Commerce Clause. Second example. When the Commerce Clause legislation was first, when the Commerce Clause decisions were first being made, one of the things that the judges had to decide was, what is commerce? There's an incredibly complicated debate about how you classify commerce. And in some occasions, it was decided that something wasn't commerce, which later it became extremely obvious was commerce. Now, the most famous example is insurance. There is an 1869 decision, Pauley versus Virginia, which decided that insurance wasn't commerce. Right? So what that meant is the insurance market in America is balkanized. Right? And you don't get cross-border competition between insurance companies, or it's very limited. It's not none, but it's very limited. One of the implications of that was to enormously complicate the Obamacare legislation, because Obamacare has these health exchanges. And because the American insurance market is balkanized into 50 states, there are 50 Obamacare health exchanges. And trade between these health exchanges is not permitted. That is all a consequence of an 1869 decision, Paul versus Virginia, that insurance wasn't commerce. Because it wasn't commerce, it didn't deal with interstate commerce. Your point is the internet. The internet is a new technology. And what happens when these incredibly new disruptive technologies come along is that the Supreme Court has to play a game of catch-up. What the Supreme Court has to do is it has to bring this new kind of commerce, it has to bring this new kind of economic activity within the ambit of the Commerce Clause. So it has to somehow define it as commerce. And if it can't do that, it loses control. Right? Now, does that answer your? That's my attempt to answer your question anyway. But there is a literature on the internet and the Commerce Clause and how the internet should be governed in the light of the Commerce Clause. Right? Okay. But what I think the lesson that I draw from those cases where the Commerce Clause isn't applied, it's like a natural experiment. If you arbitrarily say a particular kind of economic activity is not subject to the Commerce Clause, then if the 19th century Ricardo Gladstone view is right, it won't matter. If the 18th century Hamiltonian view is right, what's going to happen is the states are going to erect barriers, and that's exactly what they've done. Every time a particular kind of economic activity is exempted from the Commerce Clause, what you get are barriers to trade. Right? Sorry, does that?
Yeah, that does.
Okay. Anybody? Go on. There must one more. Should we have 2 more questions? Yep. I can see that.
So why is there a resurgence of the 19th century Ricardo mentality in the Conservative parties on both sides of the pond when it's failed in the past and the 18th century seems to be the way?
Okay. I hoped I'd answered. I thought my lecture was an attempt to answer that, right? So in the last 10 or 15 minutes, I was trying to answer that. What do people think was my answer? What was I saying? I mean, I did give it. I mean, obviously you didn't follow my. That's not. But what was I saying? Why was it that these conservative free market economists back away from supporting what seems to be a free market policy? Why do they back away from it? Sorry?
It's embroiled with liberal kind of views.
Say that again, but louder.
It's embroiled with kind of liberal views of free movement and kind of social state.
That was the central, that's the kind of the punchline of my lecture, is that once conservatives discover that the Commerce Clause can be used to do things like justify the 1964 Civil Rights Act, they back off. Once they realize that the Commerce Clause can be used to justify Roosevelt's New Deal legislation, they back off. Once Mrs. Thatcher and her cabinet discovered that the single market program was going to be used to defend workers' rights, they back off. That's the story. Well, that's my story. Okay? I mean, you know, yeah? Does that answer your question?
Yeah, thank you.
Perhaps we should stop? I don't know.
Can everyone join me in a final round of applause? Thank you.